hearing and a bail hearing. I've had the opportunity to meet with the attorneys in chambers, and it does appear that there has been some type of an arrangement reached between the parties. Mr. Findling, would you like to go ahead and state that for the record, please?
Yes, Your Honor. Your Honor, counsel for the state and myself have been in negotiation really since yesterday, but throughout this morning, and I've explained those negotiations. Counsel for the state and myself have been in negotiation really since yesterday, but throughout this morning, and I've explained those negotiations to Mr. Golden. We are going to waive a preliminary hearing in this matter. In exchange for that, a bond will be set at $100,000. Mr. Golden will be able to use a commercial company to make that bond. That will be an aggregate bond covering everything in total, as contained in the charging instrument.
All right. Thank you, Mr. Findling. Mr. Keller, does that accurately represent the agreement that's been reached between the state and Mr. Golden?
Yes, it does, Your Honor.
All right. Mr. Golden, have you had enough time to speak to your attorneys about this decision to waive your right to your preliminary hearing?
Yes.
All right. Do you understand that the standard at a preliminary hearing is a much lower burden of proof that the government would have to meet than at trial? So instead of proof beyond a reasonable doubt, it's a lower burden of proof, which is there a reasonable belief that a crime was committed by you? And the court has to view all the evidence that it would receive in a light most favorable to the government, to the prosecution. Understanding that legal standard and having had discussions with your attorneys, do you hereby waive your right to your preliminary hearing?
Yes.
All right. The court finds that Mr. Golden has knowingly and voluntarily waived his right to his preliminary hearing. He will be bound over for trial on all the charges set forth in the information, the charging document in this case. Bail will be set through stipulation of the parties at $100,000. That will be bondable. And in talking to the attorneys, it sounds like they would like to set this out for an arraignment at a later point in time. Mr. Findling, would you like to go ahead and articulate anything specific related to that?
Yes, Your Honor. As discussed in chambers, and I explained to Mr. Golden, even if it's set up for arraignment, say in 60 days, the court has made it clear through discussion